Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. If you were just with me when we read that last document, I was about ready to turn in. And then these documents came out. One of them is 200 plus pages, and I am exhausted and overwhelmed. So here's what's going to happen. I usually go through the full thing the night these things come out, and then I skim through it and I'll recap the next morning. But it is a Friday night, so we're going to skim through it tonight, and then I'm going to go through everything tomorrow. So in response to the letter that we read in the last stream regarding Stephanie Jones not wanting her security company to answer to the discovery requests, Wayfarer has already responded to that. We're not going to go over that on this stream because we have Blake Lively's documents to go through, but just as a kind of sneak peek, like I said, I'll go over this tomorrow. It says the crime fraud exception strips the privilege from attorney-client communications that relate to client communications in furtherance of contemplated or ongoing criminal or fraudulent conduct. So you see how that's going to go. But we'll skim through these other documents that came out together and try to get an idea of what's going on. And then tomorrow I will lay it all out for you. But tonight's been, oh my God, crazy. All right. Sorry if you already mentioned, but why does your screen go black out of nowhere? Did it go black out of nowhere again? Oh, I didn't notice. I don't know. Usually there's a problem with StreamYard, so. Okay. Dead dentists prefer brains. Thank you for becoming a member of the channel. I appreciate you. Okay, let's go to document number 200 here. You know what? Let's start with 203 because that's 20 pages to the other one's 200. So how about that? One sec. Okay. This is nuts. It looks like 1,000 pages drop. Dude, it's... my brains are leaking out of my ears right now. God, I'm so tired. It was your microwave blowing up again with soup. Thank you for that vote of confidence, ma'am. Appreciate it. All right. Okay, so like I said, we're just going to skim through this tonight. We're not going to go over word for word. And then tomorrow I'll do the whole thing, the whole shebang. And, you know, maybe my brains will be back in my ear holes by then. We'll see. All right. Dear Judge Lyman, on behalf of Blake Lively, we write pursuant to Rules 1.c and 4.c of your Honor's individual practices to respectfully request an order compelling defendants, Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, blah, 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 to produce documents in response to 8 requests for production, seeking materials relevant to their collective and specific demand for at least $400 million in damages against Miss Lively. The footnote here says, TAG is the only Wayfarer party not named as a plaintiff in the Wayfarer action. Okay. However, given that Nathan claims harm to her business and profession, she therefore implicates TAG. Okay. Prior to filing this motion, counsel for Miss Lively met and conferred with counsel for the Wayfarer parties, but the Wayfarer parties have refused to produce the documents requested in the financial RFPs, committing only to produce non-privileged documents concerning their damages, rather than comply with the RFPs actually served. To make matters worse, the Wayfarer parties refused to divulge even the most basic information relating to their collection efforts, which apparently are still underway and have left Miss Lively completely in the dark with respect to what documents and information may be in their possession. But the Wayfarer parties are not permitted to hide the ball like this, and they do not get to choose what documents are and are not relevant to their own $400 million damages claim. The financial RFPs seek documents that are plainly relevant and within the scope of Rule 26. Lady, do not talk to me about a Rule 26, and if you've been around this channel long enough, you know why. The Wayfarer parties must produce these documents, and given their refusals thus far, the court should compel them to do so. All right, here's the background. Wayfarer parties have claimed by making public allegations of sexual harassment and retaliation, Miss Lively destroyed their personal and professional reputations and livelihood, claiming harm to their businesses, their reputations, and even their blockbuster film It Ends With Us. Well, yeah. The Wayfarer parties have described their damages in dire and astronomically high terms, alleging that Miss Lively's public disclosures have cost them their film and their reputations, their future prospects, even their talent agency. Okay. These allegations are collective as to all of the Wayfarer parties, including Jennifer Abel and Melissa Nathan, the PR specialists, even though the film is not theirs. All of the Wayfarer parties claim to have suffered similar financial harm and collectively seek in excess of $400 million. The financial RFPs seek standard financial information from the Wayfarer parties that is commonly exchanged in litigation. 2, the Wayfarer parties must produce their financial information. Okay. They have placed their respective financial conditions squarely at issue. This, of course, necessitates production of documents showing the Wayfarer parties' financial condition, including the specific documents requested in the financial RFPs to demonstrate their alleged harm to the tune of 9 figures. Yet each of them has so far refused to produce specific financial records that would be relevant to whether that alleged harm actually occurred. But having invoked the jurisdiction of this court, the Wayfarer parties must now produce evidence relevant to their claims. The financial RFPs are tied directly to the Wayfarer parties' highly specific demand for $400 million in damages, which they claim is based upon, among other things, lost profits and reputational harm. Okay. Much of the Wayfarer parties' case centers on the notion that 1, Miss Lively defamed them by alleging that she was sexually harassed and then subjected to a nefarious retaliatory astroturfing campaign designed to destroy and bury her credibility and reputation. And 2, they were each harmed when, according to their conflicting theories, Miss Lively either used the sexual harassment allegations or used her power to take creative control of the film. As such, obtaining the Wayfarer party's financial records is critical because, by all accounts, the film was a box office success, a fact that the Wayfarer parties cannot dispute. Well, how convenient of her to wait until after the success happened to drop her New York Times article, I guess. In fact, recognizing the success of the film, Mr. Baldoni anticipated that there would be a lot of buzz around how much money the movie made. He was right. By the end of August 2024, total gross profits for the film had already exceeded $350 million, and at present, net profits are projected to eclipse $200 million. What? Okay. Despite this, the Wayfarer parties have alleged, in contradictory terms, some unclear financial loss, including lost profits related to the film, but refused to produce the requested documents bearing on that loss. Instead, voice crack. Instead, in response to each request, the Wayfarer parties asserted kitchen sink objections as to burden, attorney-client privilege, but not tax privilege, confidentiality, and even relevance. During the parties' meet and confer, however, the Wayfarer parties did not articulate any basis for any of those objections, and instead took the vague position that they were withholding documents responsive to these demands solely based on scope. Simply put, the law does not permit that the Wayfarer parties, what the Wayfarer parties seek to do here, claim financial harm but then refuse to turn over specifically requested financial records. In favor of some unstated alternative set of documents they subjectively deemed sufficient to demonstrate damages. On the contrary, Ms. Lively is entitled to receive all relevant financial information to disprove the Wayfarer party's damages and expose their lawsuit and its frivolity. Okay. So a lot of this is sealed, so we're not going to see these exhibits. Right. So it just says sealed, 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 which would be great if this was the only thing I had to go through tonight, but there's another 200-page fucking document. So, all right, let's see what his email says. From Matthew Bruno to Kevin Fritz. Okay. Kevin, in your email below, you state the Wayfarer parties will produce non-privileged documents concerning their damages. We never agreed that this was an acceptable manner of proceeding, and it is not clear from your email whether the Wayfarer parties intend to produce documents responsive to the financial request identified in my April 28th email. What? It says they will produce non-privileged documents concerning their okay. That's a little weird to me. Based on our conferral and your email, we understand the Wayfarer party's position to be that they intend to stand on their objections and will not produce the materials requested in these requests. We will proceed accordingly. Separately, we understand your email below to amend the Wayfarer party's prior objections and to confirm their agreement to conduct a reasonable search for and produce all non-privileged documents responsive to the request identified in Schedule A to Ms. Lively's April 15th, 2025 deficiency letter. Okay. So these are, oh my God, this is again like a set of objections to what they're requesting. And the objections to me, honestly, like, and I'm not a lawyer, but some of these do seem kind of like petty, honestly. On both sides, what's being asked for and what's being responded with. So I don't know. I just gotta say, I feel like there's a lot of resistance here where there doesn't necessarily need to be, but there's so much animosity that how could there not be? You know what I mean? But that's just me. Don't fuck with justice. Thank you for the 5 for a coffee. Thanks for being so on top of the doc drops. Thank you. I do my best, but I'm flailing tonight. This is a lot. But thank you for the 5. I appreciate it. Okay. Let's see. What do we got here? The Wayfarer party's refusals to produce Schedule B and Miss Lively's deficiency letter. Okay. This is, we're going to skim over a lot of this. Oh my fucking lord. Jesus. I'm sorry. Sorry. What is that? Sorry, my stupid thing is going off. There we go. Okay. Well, we'll just read the part in red. Your recitation of the conversation is incorrect and incomplete. When asked to explain the relevancy of categories of documents sought by these requests, you replied, damages. You failed to explain, because you cannot explain, how documents concerning net worth or liquidation of assets are relevant to the damages incurred by the Wayfarer parties. Furthermore, I advised you that the Wayfarer parties will produce non-privileged documents concerning their damages. I further advised you that, if upon receiving such documents, you believed that additional documents should be produced, you should notify us of that position. You agreed that was an acceptable manner of proceeding. Oh, good. Okay. This is regarding the Van Zandt stuff, so we'll go ahead and read that. The Wayfarer parties object to request number 60 propounded upon Mr. Baldoni and will not search for or produce documents or information responsive to this request. Request number 60 seeks information regarding Mr. Baldoni's asserted neurodivergent conditions, which he admits he has communicated about in connection with Miss Lively's allegations and has relied on to explain his alleged sexual harassment, retaliation, other inappropriate behavior on the set of It Ends With Us. That's fucking sick, dude. Like, you could tell based on their text messages that they were friends. Like, they were having friendly interactions. They were confiding in each other. Things that you don't say to like a random work colleague. So for him to talk about his like neurodivergent status or whatever, and for her to harp on that and be like, you're a freak. Because that's my understanding of what's happening, and that's why she's complaining. What the hell, man? All right. This information is demonstrably relevant to Miss Lively's claim, including but not limited to her claims of sexual harassment and retaliation in violation of Title VII. And honestly, there are things like I can say and there are things I can't say. But in some regard, certain symptoms of neurodivergence, of conditions that people consider to be like, neurodivergent, they come off as like it's hard to say no to people. It's hard to push back against people. Or sometimes you over-explain yourself. Let's think back to that voicemail that we all heard, or that voice note, or whatever that was sent late at night. That stuff matters in context. That's important in context. Not that it was sexual harassment in the first place, but in the context of, hey, this is just how this guy is wired. That matters. Jesus. All right. Okay. I'm seeing the Van Zandt stuff here, so. Your recitation of the conversation is incorrect and incomplete. When asked to explain the relevancy of the health-related documents sought by request number 60, you replied, it's in the discovery. I then asked you to what discovery you were referring, and at that point you realized that 1, no discovery has been exchanged between the parties in this action, and 2, you should not have referred to the discovery that your firm obtained through the New York State court action, in which, from our viewpoint, you purposely omitted Lively as the plaintiff and listed her company Van Zandt as the plaintiff. What? Hold on. Your recitation of the conversation is incorrect. One has to explain. What discovery were you referring to? And that point, you realize that no discovery has been exchanged? You should not have referred to the discovery your firm obtained through the New York State court action, in which, from our viewpoint, you purposely omitted Lively as the plaintiff and listed her company Van Zandt as the plaintiff. Okay, yes. And purposely omitted one or more of the Wayfarer parties as defendants so that, okay, this makes sense now. A, no one would know that Lively had, in essence, commenced a lawsuit, and B, the Wayfarer parties would not receive notice that Van Zandt, i.e. Lively, had served a subpoena. In an effort to retreat from your reference to such discovery, your colleague Michaela then referred to Lively's allegations on page 60 of her amended complaint. However, paragraph 188 of page 60, which you cite above, purports to quote from a text message that appears to have been obtained by your firm in response to the Van Zandt subpoena. In other words, both you and Michaela were referring to the same discovery that you obtained without notice to the Wayfarer parties. If your firm wants to explain to the court how your firm obtained information concerning Baldoni's purported medical condition and attempt to explain how it is relevant to Lively's claims, we welcome the opportunity to respond thereto. All right, then. All right. That was the first document. Here's the second. And like I said, we're just going to skim over the second one. It's over 200 pages. I cannot read that word for word tonight, but Jesus. This is such a mess, dude. And I don't know if things are always this much of a mess, but they're such a mess right now. Okay. Dear Judge Lyman, okay, let's see, pursuant to rules 1.c and 4.c, submits this letter motion to compel. A lot of this is going to be the same shit, it looks like. The Wayfarer third parties are each current or former Wayfarer executives and employees and are likely to possess documents and communications relevant to the claims and defenses. So they're asking for like Tara Hanks. I think she was the president of Wayfarer. And there's some other people here who were either currently or previously involved with Wayfarer Studios in that type of capacity. So let's see. Wayfarer and the Wayfarer third party's gambit improperly seeks to extend the third party's deadline for compliance. The subpoena compliance deadlines have passed, plain and simple. The Wayfarer third parties cannot evade the deadline by outsourcing their obligations to Wayfarer, even if they have agreed to be represented by Wayfarer's counsel. Meanwhile, Wayfarer's decision to insert itself and its counsel into the process of responding to the subpoenas issued to the Wayfarer third parties is not an excuse to delay or otherwise evade compliance. All right. Here's a subpoena. A lot of these exhibits are going to be subpoenas. Give me a sec. And this is like attachments to the subpoenas here. So like they're requesting certain answers to certain questions or documents relating to certain events or subjects. The definitions and stuff like that, it's not something we need to read through. Give me one sec. Sorry, guys. Tonight, if we can skim over it, if it's not like super pertinent, then that's what we're going to do, because this, like I said, this is over 200 pages and a lot of it is just this subpoena and request type of stuff. And it's not telling us too much. The letters are where all the real information is, it seems like. So let's see. How would I do this? So you don't have to listen to my mouth scrolling this entire time. I'm going to mute myself while I scroll through this. So just bear with me for a minute, okay? I mean, thank God most, if not all of this is repetitive, because I would be so tired if it wasn't. Hang on, let me see. Yeah, it looks like they're all subpoenas. And I'm curious as to, because when I'm looking at the documents in the docket, it kind of seems like some of this was the stuff that they meant to redact, but I'm not positive. So I'm gonna scroll through. Yeah, these are subpoenas to like current or former Wayfarer employees. So a lot of this is just like not super interesting right now. Lauren is literally carrying us over this finish line. Blake is insufferable and exhausting. I agree with part of that. I'm not going to tell you which part. I think you can figure it out, though. All right. Yeah. We're still at the subpoenas and production requests. If there's any more letters, we'll go through that. If there's not, then I'll skim through the rest of this tomorrow and put something together for you guys. Yep. More subpoena. And we're over halfway through the document now. So this is like, wait, some of that was kind of weird. I know I just saw content creator shall refer to any individual or entity who sees, generates, creates, or influences social media. So they're probably going to ask about, have you been talking to certain content creators, namely Megyn Kelly, who was Brian Friedman's client. But that's not a crime, to my knowledge. All right, let's see. Honestly, these are like random employees who are not public figures. AJ Marbury. Like, so I've never heard of most of these people who are being subpoenaed. What pisses me off the most is knowing that when they go to trial, they're going to try to bring up Justin's, mental health stuff. And it's one thing to say your damages were mental health related, right? To say, like, I was so distressed that XYZ happened to me, or I came down with PTSD regarding certain events and stuff like that. But then there's forcing someone to explain their neurodivergent status in front of a court in a high profile case where, even though it's not televised, is going to be widely reported on. That makes me so sad for him, man. Jesus. I mean, the guy's a good person. He's got a good family. They're good people. One day we'll talk about all of this, but can't right now. All right. If these are all production requests, like I said, I'm just going to scroll through them. Honestly, that's a blessing to me because I'm tired as fuck. All right. Counsel, we strongly disagree with the self-serving characterizations in your email. Nonetheless, we reiterate that our clients have complied and will continue to comply with all of their discovery obligations. As we made clear during our call, we are fulfilling all requirements under both the federal rules of civil procedure and local rules. To be clear, as expressly communicated, we are actively collecting materials from all relevant sources, including Wayfarer's servers and databases, as well as personal devices where applicable. This collection applies to both the Wayfarer parties and the affiliated third parties subject to subpoenas. As also discussed on our call, the collection process is well underway, and we expect to begin a rolling production by the end of this month. Your attempt to distort the record to suggest otherwise is not constructive. Notably, as during our call, you have cited no authority supporting your assertion that you are entitled to detailed information about our collection process. Separately, and as previously confirmed, Wayfarer, as a party, is collecting all professional materials from the subpoenaed third parties in connection with their compliance with the Rule 45 subpoenas. To the extent additional responsive and relevant materials exist, they will be identified and collected from the subpoenaed individuals. To avoid duplicative productions, Wayfarer intends to produce responsive and non-privileged professional materials collected from its own repositories on behalf of itself and the affiliated third parties, while the subpoenaed individuals will produce any remaining responsive and non-privileged materials located on their personal devices. If you object to this approach, please let us know. So what the fuck is the problem? I mean, this was May 8th. The 2 days yesterday. This is fucking yesterday. What is your problem? Okay, so this is from Michaela Connolly, counsel. We write to memorialize our May 5th conferral regarding the party's collection efforts to date, as well as the Lively Reynolds party's third-party subpoenas to Tara Hanks. And then there's a bunch of other people related to the Wayfarer production, or not production, but the Wayfarer Studios company, whatever, whoever's, Tara Hanks was, like I said, the president currently or formerly. I'm not sure. I think she's still the president, but I'm not positive. Others are just regular Wayfarer employees, I think, or people on the board or something like that. So yeah. Somebody says, was it Manet, the firm that filed the Van Zandt lawsuit? Yes. Samantha Katz on behalf of Manet. Okay. At the outset of our discussion, we requested confirmation of the individual Wayfarer parties' document collection efforts. In response, you advised that the Wayfarer parties were making collection efforts consistent with their obligations and stated that addressing collection efforts on a party-by-party basis was inefficient. We disagreed and separately asked for confirmation of the sources from which the Wayfarer parties are collecting documents. In response, you represented that if a source has relevant information, you were collecting that source's data. Okay. You stated that you are collecting from Wayfarer's servers and databases, which would purportedly include Wayfarer emails, and from personal or work devices to the extent such devices contain relevant information, but you would not provide any details or answer any questions about what repositories in particular you are collecting. For example, we requested that you specifically answer the following, and you declined to do so. 1, what constitutes a device? 2, what specific Wayfarer servers and databases are being collected? 3, what materials are housed within these servers and databases? 4, whether the Wayfarer parties' collection efforts are partial or complete? 5, whether the individual Wayfarer parties have Wayfarer-issued phones or use their personal phones for work-related communications? And 6, whether Solomon and Benson, individuals subject to Rule 45 subpoenas discussed further below, are Wayfarer employees. You also refuse to divulge any basic information relating to the Wayfarer party's document collection efforts, including what custodians you have collected documents from and from what repositories. We do not understand how Wayfarer can represent that it is making all efforts consistent with its obligations when it cannot even identify who it is collecting materials from, including to confirm what devices, emails, or other repositories of information it is collecting from the individual defendants. As we explained, the information we are asking about is standard information that is shared by parties at the outset of discovery. Based on our call, we can only assume that Wayfarer has not completed and maybe has not even started its collection obligations. Okay. Rather than address these items, you demanded information regarding the Lively/Reynolds party's collection efforts, including on the same topics on which you refused to provide answers. We confirmed that the Lively/Reynolds party's collections were fulsome and complete. As we have been telling you for many weeks, we are eager to enter the ESI stipulation that we first proposed more than a month ago so that we can begin producing materials and make every effort to comply with the July 1st substantial completion deadline. We do not understand how the Wayfarer parties can possibly be attempting to meet that deadline if you cannot even confirm that you have begun or finished collecting all of the repositories likely to contain relevant information for all the defendants, including Wayfarer custodians. We asked whether you could share a date certain by which the Wayfarer parties would make an initial production. You could not, and instead advised that when the Lively/Reynolds parties were ready to make an initial production, the Wayfarer parties would do the same. To that end, you asked if the Lively/Reynolds parties could agree on a date to mutually exchange their initial productions. We have considered this proposal, and subject to your agreement to do the same, will make an initial document production on or by next Friday, May 16th. Please confirm your agreement. Okay. As to the Wayfarer third parties, we requested updates on the status of their collections and anticipated productions. As we explained, each of the subpoenas directed to the Wayfarer third parties have been pending since March. Okay. I'm like, what date is it again? On a March 25th conferral, you represented that the Wayfarer third parties would produce all responsive, non-privileged information in their possession, custody, or control in connection with all of the subpoena requests. Notwithstanding that representation, we have yet to receive a single document from any of the Wayfarer third parties. In response to our repeated requests for information regarding the Wayfarer third parties' collection efforts, you indicated only that they are still in the process of collecting responsive material from sources with relevant information. As we explained by way of separate email, we understand that the Wayfarer third parties are responsible for collecting, searching, and producing all relevant and responsive materials from their personal and professional repositories of information, and will continue to understand that that to be the case until you confirm that Wayfarer is assuming responsibility for any of the Wayfarer third parties' compliance with the now overdue subpoena responses. If you would like to clarify or correct any of the above, please let me know. We reserve all rights. Michaela Connolly. Okay. So that's the end of it. Like I said, I'll go over these a little more thoroughly tomorrow. We can talk about it then. I think Omar's probably offline by now, dude. But let me double check. No, he's still on. All right, let me send you back over to Omar, and maybe I'll join him in a second if they're not wrapping up over there. But I need a little break to really go through this and make a recap for you guys. Some of this stuff is very... I can't. Yeah, I just can't handle some of it right now. So we'll deal with it tomorrow. Give me 1 second. These are good people. I'll say that. These are good people that are being fucking smeared and falsely accused of sexual harassment. And it breaks my heart. And there's only so much I can do. But I will be here paying attention the whole way through. Let's put it that way. Okay. I'm sending you over to Omar, and I will talk to you guys soon. Thanks. Send lots of bacons, yeah? Oh, and also, Busted Can of Biscuits, thank you for the 5, and Froggy, thank you for the 2. I appreciate you. See you later.